Good afternoon. I'm Dan DeRosa with 19 News, coming to you from our digital desk. We want to get into this, really some new information that we have uncovered here at Cleveland 19 when it comes to self-defense cases. Going to be very open and honest about how we came to start to ask some of these questions of the Cuyahoga County Prosecutor's Office. If you hadn't heard, last week there was a road rage incident in Valley View. An individual exited his kind of van, gray work van, and according to the Valley View police, he was the aggressor as he approached another vehicle. That vehicle then used a gun to shoot and kill that individual, and then they took off. Their vehicle somehow caught fire. They were hiding. Police found them. According to the Valley View police, they believe that that was self-defense, that the man who got out of his work van was the aggressor. So it started us asking questions of what determines a case of self-defense, and through a series of questions with the prosecutor's office. And I want to be very, very clear. The prosecutor's office has not reviewed the Valley View case as of yet. That is simply the Valley View police saying they believe this will end up being a self-defense case. So that case then heads to the county prosecutor, and generally the prosecutor will look at the evidence, decide whether or not to go to a grand jury, but that's where we sort of have to stop. Because in our series of questions with the prosecutor's office, we found out that this process is very different. And in fact, in a case where someone is claiming self-defense, there is a self-defense committee within the prosecutor's office. You might ask who sits on that self-defense committee. And it is Mr. O'Malley, Michael O'Malley. He is the Cuyahoga County prosecutor. He's also joined by the first assistant, so the basically the lead prosecuting attorney aside from Mike O'Malley. And then the criminal division chief also sits on that committee. So then our next questions were, well, how does this committee work? How many cases? How long has it been around? You might be surprised to hear that it's only been around since 2021, but you have to remember, or at least will help you remember, in 2021, the state law in Ohio really changed as far as stand your ground. Also called the you don't have to retreat, the no retreat law in the state of Ohio. And it changed. Perhaps the biggest part of that was the burden of proof. You've heard about this if you watch any crime shows or law shows. The burden of proof is almost always on the defendant and his or her attorney. They have to prove to the jury that, hey, I didn't do it, that there was something else involved, or in the previous years that I was acting in self-defense. But in 2021, that all changed. The burden of proof then became a matter of the prosecutor having to convince a jury in a case of self-defense, no, this was not self-defense, and here's why. Or, they run the risk of spending time going into a judge, into a courtroom, spending all that investigative time, and perhaps going in front of a jury. So that's why a prosecutor's office wants to make sure they really know what they're doing, they have all their ducks in a row, and that's why there is a committee that reviews this. So then our next question was, well, how many cases are we talking since 2021? Now that we're 2-3 years into this. And we were a little bit surprised, as you might be. Let me read through these numbers. Since 2021, there have been 417 individual claims of self-defense that have been reviewed in cases. Now, 199 of those, almost 50% of those, have ended up where the individual's case was dropped. The charges were dropped or dismissed. And in those 199 cases, 58 of them involved a case where someone died. So in 58 cases, someone died, and the person on the other side of that claimed, hey, this was self-defense. So this really had us sort of interested in taking this to the next level. So who would know better than a defense attorney? And Jared Klebanow, you know him well here at Channel 19, helps us out on a number of issues and cases. Jared, thanks for joining us again today. How are you?
Good. How about yourself?
Not too shabby. Let's talk about this. First of all, I was not aware, and granted, we don't know everything. We try to have our fingers in a lot of different areas, but I didn't know that there was a self-defense review committee within the prosecutor's office. You're a defense attorney. Is this something you knew about?
No. So the inner workings of the prosecutor's office wouldn't be something they would have to disclose, right? How they make their determinations of whether or not they want to bring charges is something that's at the discretion of each prosecutor. So, in looking at the figures that Channel 19 was able to get, it was an interesting look to see not only how the process plays out within the inner workings of the prosecutor's office, but those numbers. Very interesting to see the high number of claims of self-defense, and particularly those that involved a death.
Yeah, 58 times. So if we're talking, and I'm going to do some rough math, that's why I'm in journalism and not an accounting field. That's about, if there's 200 cases that involved people getting their charges dropped and 58%, 258%, you're looking at what, a quarter of those cases, if my rough math was right, roughly a quarter of those cases were involving fatalities. What is it about that number that surprises you just a bit?
The high number of self-defense just cases in and of itself, and I think what it shows a lot of people, and it's a lesson that people here can learn, especially on the road. We're seeing a lot of these road rage incidents, like the Taco Bell incident, which occurred, I think it was in Stowe, Streetsboro. We have this Valley View incident. Realize that if something like that happens, it's not always the best idea to try to confront somebody else. With the new laws in the state of Ohio, you don't know who's sitting in that car on the other side, and if cooler heads can prevail, you may not only save your own life but lives around you. So I think it's an important lesson off the bat when you see those numbers, that if it's something you could take a deep breath and move on from, we can all learn to do that better. And I think that can cause a lot less conflict and keep those numbers down.
And you have to look at that in a way, not to say, well, I can just shoot somebody and claim self-defense. Look at it on the other side. That person can claim that you were in the wrong and that you were the aggressor in this situation, and they shot you and perhaps got off on a claim of self-defense. It is an interesting perspective, and Jared, you're right, this is happening way too often. Heck, I've even told family members, you've just got to stop. The honking of the horn, the flipping of gestures, it's just not worth it anymore. Because people just don't seem to have anything to lose anymore, and it is a scary situation out there. Let's talk about this idea of, and I want to read word for word how this works from the prosecutor's office. What is the review process like is the question we asked. And from the prosecutor's office, the person's claim of self-defense is reviewed by the committee, which includes the case evidence, things like phone records, video, witness, and victim statements, etc. The determination is made as to whether the state of Ohio can overcome the burden of proof beyond a reasonable doubt that the individual was not acting in self-defense. Jared, I mentioned it earlier. This is a huge shift. You are a defense attorney. You are normally responsible and have the burden of proof, have to prove to a jury that my client is innocent. In a case of self-defense, it is the prosecutor that has to sit there, present all the evidence, and try and convince that jury that this was not self-defense. Why is that such a huge shift?
Yeah, so in most cases, almost all cases, it's the prosecutor who has it, right? The prosecutor is the one, the state always has to prove beyond a reasonable doubt that the defendant is guilty. There had been in the past the issue of specifically self-defense, which is an affirmative defense, something that the defendant brings up and they are required to show. That has shifted to the state as well. So the state carries essentially all of the burden, not anything where it's split between the affirmative defense of self-defense and not now it's the state's responsibility. Anytime that the prosecutor looks at a case, the first thing they're going to look at is, do we have the evidence to overcome this high burden beyond a reasonable doubt? Unlike a civil case where we're looking at the 51% against 41%, criminal case beyond a reasonable doubt, the defendant is just having to show any reasonable doubt. Could it have been somebody else? Could there have been some other alternative theory? So when the prosecutor now looks at these self-defense cases, they know they have to prove that this was not a self-defense issue. So in a case where we've talked about somebody gets out of a car, is angry, and is waving a fist at somebody or brandishing a weapon, does that open the door for an individual who's scared or threatened to take action? And it is now harder for the prosecutor to overcome that burden. So, what that means in practical terms is they are going to even have to look at those cases with an even closer eye to say, do we have the evidence to overcome this burden? And if we don't, or if it's close, maybe this is not the case we put our resources into and we put them into another case, thus resulting in more of these cases which go before the review board, essentially just being non-charges or no charges brought.
Yeah, it is a very interesting sort of shift here, especially when it comes to self-defense. We've seen this discussed around the country, whether it's the Castle Law, whether it's the no retreat law. It is very different and very difficult to navigate around. And the fact that the prosecutor's office has created this new committee since 2021 kind of shows you where this is headed. Jared, anything else on this topic that you think we're forgetting or that we need to talk about?
Yeah, no, I think it's generally been touched upon. Like I said, I think that the numbers are a bit staggering and they are a bit high. And what it shows that the prosecutor's office is doing with this subset committee is saying, look, we have to put additional resources now that the burden has changed into making these determinations. And, it's up to each individual prosecutor whether or not they charge on. What would be interesting is around the state of Ohio, you may have some prosecutors more inclined to charge on these kinds of cases that are more inclined to say, look, we can't have more violence. We can't have people, we can't make the stand your ground law grow further and empower people to act fast. On the flip side, you have another group of prosecutors which might be more in support of those castle doctrines or stand your ground law and are less likely to charge if they see any inclination that the person defending themselves was not the aggressor. So as I said at the beginning, with the change in law, the staggering numbers, and like you said, Dan, if there's any way for people, for themselves and their families, to say, look, if somebody cuts you off on the road, if somebody does something to you that you're not happy about, move on, right? Don't honk your horn. Don't, no hand gestures. Don't yell out the window. You don't know who's on the other side of that car or in that car or what they may have in that. Keep yourself and your family safe. Let cooler heads prevail. And if possible, walk away from the situation.
And what that person might claim after the damage is done. If they get out of their vehicle and say, hey, this person cut me off, they flipped me something in their hand, I thought it was a gun, so I fired in self-defense. You have to think about that. It is a dangerous scenario. Jared Klebanow, defense attorney here in Cleveland. We certainly appreciate the time. You're very generous with your time here for Cleveland 19, so we certainly appreciate it. Thanks for joining us.
Of course.
All right, take care. Again, just a discussion we wanted to have. It's come up in the news and the headlines recently, and with the new information we are able to get from the Cuyahoga County Prosecutor's Office, certainly is eye-opening. Look for our 3.5 hours of news to start in just about 45 minutes on Channel 19. Again, 3.5 hours of news and weather. We are in a first alert weather day because of that excessive heat. You can see it's an 89 degrees in Cleveland, and we still have a couple of hours to go of sunlight. So we'll see you at 3 o'clock on Channel 19. I'm Dan DeRose with 19 News. Have a great day.
19 News is everywhere.